cord going to be long enough, Zach? My shoe is not going to work out. I know I look good with this, huh? Little wires sticking out. All right, well, Happy New Year. All right.
2020.
2020, can you believe it? The year of the optometrist, huh? Or optimist. Welcome to RentPros, property management production or seminar here, whatever. You are in the Rental Owners Association office right now. This is the, we are the only management company as of yet. Well, actually, there's one in Yuba City associated with the Rental Owners Association. The Rental Owners Association is just that. It's an association for rental owners, people who own rental properties, want to keep up on the rules. What you're going to learn tonight is that, you know, what we used to worry about before was peanuts compared to what we have to consider now, subsequent to the passage of Assembly Bill 1482, rent control measure. The city of Sacramento did theirs a couple of months prior, and yes, so let me make sure we're all working here, and we are. So, as you know, a couple Novembers ago, we had a rent control measure on our ballot, and we all voted no. We don't want that. 63%, 2-1, right? We don't want rent control. And in their infinite wisdom, the legislatures listened carefully, and they wrote their own rent control bill and passed it anyway. Governor signed it in September, and so here we are with rent control. Now, how many of you are realtors in here? Okay, good. This is really geared for realtors. So it used to be, and if you saw me, how many people saw me at P-Card do this? Okay, and I changed this up a bit for you, so you shouldn't get, and it was kind of like I couldn't get anyone to listen to me about rent control for the past year. Realtors are like, no. I even went to the Placer County Association of Realtors and tried to put it in a lunch and learn, and they went, kind of boring, and so they didn't do it. And lo and behold, they contacted me here just a while ago and said, hey, what about that rent control thing? So they're actually voting on it tomorrow to tell me whether they're going to have us come in and speak or not. Now, usually my attorney is with me. By the way, I'm sorry, my name is Chris Airola. I didn't tell you that. And my attorney, Thomas Hogan, is usually with me, and he just texted me that he got held up tonight. So we'll be fine without him. He oftentimes will expand on something that I'm saying. But we'll just go forward, and if you have questions, raise your hand, and we'll probably cover a little more than what I have planned, and that's fine. Rent control is a very, very broad topic. So it used to be not your problem, and it definitely is now. How many people have ever sold a duplex, or listed a duplex, or bought one, or a triplex, or a fourplex? Okay, so even a single-family home. Have you heard that single-family homes are exempt? You're going to find out that they're not necessarily exempt. So I want to give you a scenario, because we're going to come back to this scenario. So let's imagine that you plan to sell or list, right, a tenant-occupied duplex, triplex, fourplex, and your buyer wants one of those units vacant at close of escrow. Don't they usually? I mean, that seems to be the most common. In fact, we just sold, what, 16, 17 duplexes last year for one of our clients, and every one of them we made one side vacant. That's how they all sold the best. We used to do that by giving the tenant, say, 30-day or a 60-day notice, depending on how long they'd been there. We don't even have those on our website anymore because you can't use those. It's all gone. We can't give the tenant. So what do we do? What do we do? Well, we're going to talk about that. How do we proceed? Well, we used to worry about tenants' rights in terms of right of possession, right to quiet enjoyment, don't come into the property without giving notice, and all that stuff. That's like this much of what's now out there. And so let's talk about what's out there now. Rent control, it has two parts to it. It has, well, what do we normally think of when we hear rent control? What is the media? This is the only thing they talk about right here. Rent caps, right? Rent caps, that's all they talk about. And it's all about those landlords, 8.3% is not enough for them. They want to raise the rents more than 8.3% because that's how much we can raise it. And we're like, huh?
Last year.
Yeah. And so we're looking at this going, we don't raise our rents 8.3% a year. We raise them 4%, 2%. We did an average and looking at our portfolio of 1,000 properties that we manage, and it was about 4.5% that we raised rents, not 8. So we're not concerned at all about that. In fact, the bill itself, 1482 is the bill, Assembly Bill 1482. It's posted on my website, rentpros.com, and at the ROA website as well. And it's a document you print it out. It's a couple pages long. You know, it's small print. There's a paragraph, about a 4-line paragraph that talks about rent caps. The rest of it is all about the control part of rent control and all the new changes in the rules that we have. So as much as the media yaps about it, they don't talk about that. They just talk about the caps. So tonight we're going to talk about the control part of it, but let's get it over with. What is the limit that we can raise rents? Well, they tell us that we can increase rents 5%. Now, I'm talking about, by the way, the statewide rent control. There's other rent control measures in other cities, including Sacramento, but I'm talking about the statewide. It says we can raise the rent 5% plus the CPI, and we can do that once a year. Now, what CPI do we use? There's a regional, there's an area CPI, there's a something else CPI, Thomas, our attorney, told us today. Anyway, and the bill is unclear because it references all 3 CPIs in that bill, and all 3 CPIs are different. So we don't really know which one to use, but this is the consensus given out by the California Apartment Association that we can use 3.3 as our consumer price index for this area. So 5 plus 3.3, so we can raise rents 8.3%. Why do rents go up under rent control?
Landlords want the 8%.
If you're not going 8.3%, you're getting behind now. We did a presentation to a number of landlords and realtors up in Auburn this morning. Anybody at that? Okay. And there was, you know, that's what is going to happen now. If every year it's 8.3, 8.3. Well, we don't do that. That's twice what we normally increase. So rents for rent control properties will increase twice as fast as they normally do. And we've seen that everywhere rent control has been implemented, everywhere. Think about it, New York, Chicago, LA, Bay Area. Portland was an area that really adopted a very strict rent control about 2.5 years ago. And the headlines in the Portland newspaper a while back were rents soaring in Portland. But yet we passed rent control. Why? Well, it's a socially, well, forget it. That's all political. It's the way it's presented. And people start thinking, okay, yeah, that sounds like a good idea. Grandma, we don't kick Grandma out of the house. We want to freeze her rent, right? Well, it doesn't do that. Don't get me started. Here's a term for you. This is really what the bill's about. It's about something called just cause eviction. Just cause means good reason. It means good reason. And the state gives us 11 what they call acceptable good reasons to move a tenant out. And that's the only reason, those are the only reasons you can move a tenant out. There's a caveat to this. 11 acceptable reasons to evict your tenant. Now, we're using the term evict. Again, that's misused in the bill, and it's also a term that's misused in the media and reporting. When I ask somebody to leave, I give them a notice to vacate. That's not an eviction. That's a notice to vacate. An eviction is another name for an unlawful detainer, meaning I've filed a lawsuit because you didn't pay the rent. You violated the contract in some meaningful way. Selling a property is not an acceptable reason to ask your tenant to leave. What's that? Yeah. You're not allowed to move a tenant out just because you want to sell your property. That's not allowed.
Unless it's titled as single family.
Even if it's single family in some cases, as we're going to see. Huh? Okay, we'll get to that. Now, understand, these rules come into play after a tenant has lived in the property for 12 months. All this horrible stuff I'm telling you. So, I was at a NARPM, National Association of Property Managers meeting. We were going through this, and a bunch of managers said, well, I'm just going to do 11-month leases and kick everybody out at 11 months. I'm going to change the tenant every 11 months, because then they won't be subject to all this craziness. Okay, I guess you could do that. You may end up with some retaliatory action against you, and it's also going to cost a lot of money because moving people out and getting the place ready and moving people back in, lost rent, lose money. So that's not a real good solution, but it's the kind of thinking we start to get into. So what does this mean for you? As a realtor, as a seller of a property, or someone who's listing, you better know how long each tenant has been in that property before you start handing out notices. Because frankly, if they've been there 6 months, you can give them a notice to vacate, provided they're in a month-to-month contract, right? We're assuming that. If they're in a month-to-month contract, they've been there 6 months, now you want to move, you can give them that notice and it is effective. Now you may have to give them a 60, a 90, or a 120, depending on if there's rent subsidies included and that sort of thing. But don't give that notice to vacate. Let's say you give a notice to vacate. Let's say that they've been there for a year and a half, a year and a month, a year and a day. And you're going to list the property and you give the notice. And I'll say Deborah, because that's the only one I can see back there. Somebody didn't fill out there. Oh, you're wearing it right there. Okay, sorry, Mitzi. I was looking for your name on your... Okay, so you give a tenant a notice and they've been there more than a year and they move. Let's say they move. They move into a place that, I don't know, it's $100 more a month. Plus they had moving expenses, but they didn't know, so they moved. You see where I'm going? And a couple months later, somebody goes, hey, you didn't have to move. Do you think that tenant might come back and go, you know, I'm stuck in this property at $100 more a month, and I had moving expenses. I need a check from you, maybe now and every month. So you don't want to do these things. You don't want to get your sellers, because you'll get your sellers, they're the ones responsible, into a predicament where they've entered into an illegal notice that was executed by the tenant, and now you've got a problem. Do you see where I'm going with that? You can't make a mistake, because if they're there for 2 years, they're going to look back, and there could be accessory damages. So you want to make sure you know these rules. So if you have a tenant in a property and your client wants to move that tenant out before close of escrow, you better be thinking about this, maybe consulting with somebody. If you're a member of the Rental Owners Association, or have an attorney that you can talk to make sure you're doing it right, because you can expose your seller to a tremendous amount of liability if you don't do that. Okay, so we talked about just cause. Well, there's actually not just one kind of just cause. There's two kinds. There's two categories of just cause. Wait till next year. We'll have three. There's just cause where it's the tenant's fault. The tenant did something, and now you're going to go ahead and move them out. And we put this little new clause in there. You learn this phrase, just cause. We have a new one called relocation fees. So if the just cause is tenant fault, the landlord does not have to worry about relocation fees. However, if it's no fault, and we'll talk about this in a minute, there are relocation fees, so we'll talk about that. Two categories of just cause evictions. So tenant fault eviction. Well, they didn't pay the rent. That's really straightforward. If they don't pay the rent, I take them to court. I tell the judge they didn't pay the rent. I show them my ledger. They say, the judge goes, hey, tenant, is that right? He goes, yep. Okay, that's pretty open and shut case, right? Failure to allow for entry. The tenant won't let me in to do repairs or what have you because they're growing pot in there or making meth or whatever. It starts to get a little more nebulous out here, where it's engaged in illegal activity. Can be hard to prove. And the reason I said that is because the difference in the new law is that now you must prove these allegations against the tenant. So in the past, we would get calls from from neighbors, and they would say, your tenant is out here doing this, that, and the other thing, making noise, parties loud, running their motorcycles in the garage at 12 o'clock at night. And if we went out and talked to the tenant, and the tenant was like, well, yeah, but I pay rent, I have a right to do that and this and that, we'd say, no, you don't have. We'd give them a notice, a little warning, and if they didn't comply, we would just give them a notice to vacate, and that was the end of that. They had to move. Now the rule, but we have coffee. Anyone want coffee? Ben will get you a cup. Everybody's okay? Okay, that was the old days. That was 2 weeks ago. Now you have to prove. You have to prove this, which means you better have some police reports. It means, most importantly, you better have witnesses. Now, this is where my friends who manage property in Los Angeles, in the Bay Area, they tell me this is the biggest problem because for the neighbors who may own a single-family home that they own, and they're, but they live next to a single-family home that's being rented or a duplex that's being rented, and they have this problem, and they're being asked to go to court and testify against this neighbor. Well, how's that going to work out for them? They got to go stand there. Yeah, he did it. Yeah, I did. And the neighbor's, the tenant is seething. And then, so if you get them out, you still have to live with them for 2 or 3 or 4 weeks while you're going through that process. And if you don't get them out, it's a permanent deal. And if Thomas were here, he would tell you about a case that he had just a few months ago where there was a tenant, and a few months, I guess it wasn't a few, it was shortly because it was under rent control. And he had a case where there was a tenant, it was a multi-unit, and one tenant was harassing some of the women there, groping them, saying pretty terrible things when they came forward. And it all ended up in court, and the judge says, well, prove it. Prove it. And they really couldn't do that. And then the judge decided, well, this really isn't an offense that would warrant, moving this tenant out, and so he got to stay. And these, according to Thomas, our attorney, the girls were crying up there on the stand, and so on and so forth. And so now they get to still come home to this guy doing this kind of stuff. So it's really tough. This is one of the things that people don't know about when they consider voting or wanting rent control. And this is one of the most, one of the biggest problems that we see from neighbors and such. So all of those, I can move my tenant out. I don't have anything relocation fees. Now here, no fault evictions. No fault evictions. Let's say I want to move my spouse or immediate family into the property. Either myself or my spouse. I don't know why I would just move my spouse in, but here, honey, go live over here. But if I want to live there with my spouse, okay, or you intend to demolish the property and you do that, or you need to do, I don't have it up here, substantial and necessary remodeling to the property. Substantial and necessary means something that requires a permit. It's going to be taking place for more than, requiring the tenant to be out of the property for more than 30 days and so on. And, and also if I'm going to take the property off the rental market for at least 12 months. Now I can, that's a just cause. I can give a tenant, I'm going to take this rental property off the market for 12 months. Here's your notice. Now they have to go, but I better take it off the market for 12 months. And if I'm doing that, I need to provide what's called relocation assistance to the tenant, which currently, in the statewide law, is 1 month's rent. So I got to give them a free month's rent. Now, I'll take time to say and go back. There's rent control statewide, and then little cities and jurisdictions have their own rent control. In the Bay Area, some of the rent controls are some of the relocation fees are far higher than that. And I'll give you an example. I have a client that sold a duplex in Oakland, and they bought a duplex in Tahoe Park. And they were sitting here signing up their, we're managing their property, we're signing papers, and they said, we're just so happy we didn't have to pay much in relocation fees to our tenants. That's for the duplex to move out of, because they were selling the property. And they had to, what happens if you're selling, that's not a just cause, but you can still negotiate with your tenant. I want to sell it. Can you move? No. How about 1,000? No. How about 5,000? No. How about 10,000? Well, they managed to get their tenants out for $18,000, and they were happy as could be. They paid their tenants, you know, cash for keys, 18 grand, so they could sell the property. So these are the kind of negotiations that we're looking at now under rent control. Because after 12 months, I went through the slide kind of quick, there was that little thing called lifetime rights. Thank you. Lifetime rights. So I own a house. I don't have lifetime rights in my house, but tenants acquire something that the bill calls lifetime rights after 12 months of occupancy.
12 months.
Yeah. You can't move them out except for one of those 11 reasons. And many of those require you to pay relocation fees. Yeah?
So you're saying you can't not renew the lease? You have to renew the lease?
No, you don't. You can leave them month to month. That's fine. Just you can't have them move. You can't ask them to leave. You don't have to have a year lease or whatever, but they're there. They're there.
Year lease, I can't say, okay, I'm going to list the property. I still have to give relocation for the lease.
After a year, you want to sell the property.
I don't want to go month to month.
You want to move them out.
After a year, that's it. They got to move out.
You're not allowed.
But if you do the 11 months, then you give them 30 days.
Yep. But if you wait till 12 months and a day, now you're not allowed to give them a notice. They get to stay. So this goes back to my scenario question, which I'm going to answer in a little short bit here. But your wheels are turning. I can see that. Well, how the hell am I going to get them out, right? Yeah, question. I get you.
What if the person who the owner dies, now it's in the trust in the state, because they passed? I was looking through the bill. I didn't see anything on that.
No. Change of ownership has no bearing on the tenant's rights.
I bet if somebody died,
No. You would think so, huh?
well, I was looking through the bill. I was trying to,
No, there's nothing in there on that. No.
I must fell asleep reading.
Almost. I think I fell asleep many times reading it. Question.
So if you transfer them over and you don't re-sign a lease, they're just month to month. If you want to issue them a notice to vacate, you still have to do relocation fees, even if they're no longer in an agreement, it's just month to month.
Okay, so let's be careful. They're there for more than a year. You want them out. It depends what reason you want them out. If you want them out because you want to sell the property, the answer is no. They get to stay. If you want them out because you're going to move in or move your spouse in or you're going to demolish it or take it, then yes, you can move them out, but then you have to pay them relocation fees. And right now the minimum is 1 month's rent. I know, it's hard to, we all keep thinking, well, if it's in a lease and they're not in a lease, none of that matters. If their booty was in that property for more than a year, they all got lifetime rights. You can't get them out,
So Kristen,
except for these reasons.
her scenario where she said you've got an 11-month occupancy,
Yep.
and you give them a 30-day notice, does that then tack on and give them the 1 year?
Well, there's some question over that. That's been argued a lot. And in fact, as we went through this process, we didn't have rent control from September to January 1st, but still people were issuing notice to vacate. At one point, the state legislature took up an issue to cancel all notices to vacate. And we went, whoa, whoa, our attorneys went, hey, whoa, whoa, whoa. Some of these people, we told them to get out because they're making meth, because they're not paying, because they're doing this. And they went, oh, yeah. But they were going to try to cancel the whole thing where everybody gets to stay, no matter what. So, yes, to answer the question, if you issue it, let's say you wait till the 11th month, 11 and a half months, and then you issue a notice that expires, 12 and a half months. I mean, I wouldn't do that. If you did it, you're going to have to go probably argue that case, and it's going to be up to a judge to make a decision. Yeah, question.
One of the
Yeah.
reasons for eviction, when I see is noted failure to allow entry, if the property's on market, can they just deny showings, or is that still
I guess that could be a reason. Yeah, that could be a tenant fault eviction.
documented?
There's a number, I think, it's at least 3 times they have to work with you. But yeah, it comes down to the same thing, you have to be really prove the case.
And I'll take the time to introduce Steve Lanzi. He's our office manager at RentPros. He really runs the office. So here's the thing. I'll sidestep to that right now because this is what's happening. People call, they're writing us emails. We're getting about 10 or 12 of these a week, at least. I don't know, maybe more. And it's like, I just have a quick question. Well, there's no such thing as a quick question. And even the lawyers are saying, well, I can't do that anymore. You know, Tom, if he was here, he'd say, I was talking to him this morning. They have to figure out a way to deal with this because there's so many questions. The way to deal with it is come to the classes. Come to the classes. And then when you have a question, if you belong to the association, you can ask it and we can give you an answer you'll understand. Otherwise, we have to build a whole background, and I can't spend an hour teaching every person the background and then give the answer. So, and every case is different. So it's complicated. So, yeah. Michelle?
In that scenario, you talked about a 30-day notice. Are there any situations where 30 days or more is required?
Yes. Yes. If there's subsidized housing involved, like Section 8, what's that, 120 days or something? Thomas was rattling all that off this morning. Even I leave that up to the attorneys because, you know, I'll say, here's a scenario. What notice do I have to give him? And they'll tell me. Yeah, 30, 60, 90, and 120. There's your choices. And the situation depends on the situation. Yeah, question.
If you give them a notice to vacate because you or your spouse is gonna move in there,
Uh-huh.
is there a time requirement for you to live in there? Can you live in there for?
I believe that's 1 year. Yeah, 1 year.
So they can do a drive-by and figure out living there?
Yeah. If they find out you just re-rented it to somebody for more, oh, there's going to be punitive damages. You're going to be in civil court. Oh, yeah. You violated their rights. Absolutely. Yeah. And this is not something to mess around with. How many times has my office received a call that says, this is sort of a topic we're not going to talk about. Section 8, we now have to, we're not allowed to reject Section 8, just on the fact that Section 8. We've never had people, hey, do you take Section 8? Hey, do you take, I mean, we get it, but not crazy. After that bill took place, we've had like 6 calls this week and emails and stuff. They're all, that's the DRE, not the DRE, it's all the fair housing agencies testing us to see if they can trip us up. So they're coming after you. They don't try to fake them out, because if you get caught, they're going to hit you hard. I've been to fair housing hearings before, and it's not like a real hearing. It's something else. Okay, so what properties are included? Well, corporate-owned properties and REIT-owned properties, LLC properties where at least one member is a corporation, and then all multifamily, non-owner duplexes and single families as described in a minute, not earlier. Now, that are at least 15 years old. So here's the thing. The main thing to remember is multifamily that's over 15 years old. So it's a sliding scale, isn't it? I mean, you know, it's 15 years. If you got a property that's 14 years old and it's not under rent control, next year it will be, even if it's multifamily, an apartment. Now, let's talk about how single-family homes can be subject to rent control. If you're renting a single-family home to a tenant, you must give them a clause that's in the bill. They actually give you the clause in the bill that says this property is not subject to rent control. And it cites a civil code and such. And you need that specific wording. So go to my site, download AB 1482. It's right there under rent control. Steve, we should probably put up that clause because everybody's been calling asking for that. They just want that. I've emailed it like a bunch of times. And you must give them that clause. If you don't give them that clause, the single family home is absolutely subject to rent control if it's more than 15 years old.
So if the tenants are already in there and the house is 15 years old, do you need to do a new lease or give them that clause?
Say the first part of your question again.
If they've already been in the house for over a year,
Uh-huh.
and you have to then just send it to them in the mail or put them, or put it in a new lease, or?
You have to put it in the new lease. If you do a new lease, and you should send it to them as a separate addendum to your lease if you're not doing a new lease. Now, if you read the bill, specifically it says you don't have to do this till July 2020, so next July. But again, I had a tenant's attorney call me. I wrote a lease agreement for a tenant just a week ago, and I got a call from that tenant's attorney going, "You blew it. You didn't give the notice." And I went, "Yeah, I did. You know, we will do that by July." He said, "No, this contract expires after July. You got to do it now." I said, "That's not what the bill says." And I will tell you, this attorney is 100% wrong, legally wrong. I've checked with multiple attorneys, our attorneys, and they say, no, he's wrong. That's not what the bill says. But here's my take on it. If I have to take that tenant to court, and by the way, if it's a tenant that I just signed a lease with and then talking to a freaking attorney, I'm probably going to end up in court with him, right? Okay, come on. That's no way to start a relationship. So the fact is, if I have to take him to court, I don't want that noise. I don't want to listen to him having to tell the judge, and the judge won't know. He's kind of, well, wait a minute. Let's take it off the table. Give him the notice now. Just do it now. Just give him the addendum right now, and then you're done. Then if they try to bring that up, you go, here, you know, in the hall before court, you say, here's a notice, and they won't bring it up in court. Yeah.
I just want to confirm, so rent control is only for properties 15 years or older?
Correct. Yep. Okay, so that's what. If it's a single-family home, yeah, you better give that notice. Well, you know what? Do you have to give the notice even if they're less than 15 years old? Ooh. Right. So that's right. So even if a property is brand new, you still need to give that notice. Otherwise, it's subject to rent control. It's kind of, we call it a tripwire. I do a radio show on KFBK, and my, who's heard me on the radio show? Oh, okay, cool. Somebody's listening. That's awesome.
When is the show?
Saturdays from 4 to 5. I do it every other Saturday. I was on last Saturday. I'm off this Saturday. Or go to Facebook. We stream it on Facebook. Question, yeah, Lexi.
I have a question. So when my clients they're buying a new rental property in Auburn, if it's, I just want to make sure I understand, if it is older than 15 years, it can still be exempt. They just have to, that's when they have to do the clause, correct? If it's
No, you cannot exempt it if it's over 15 years old. It's good. It's under rent control. End of story.
okay.
Yeah. Hey, Joel.
Multifamily, correct?
For multifamily, she said
Single family.
Oh, single family? I'm sorry. I thought you said multifamily. Oh, single family. Repeat your question again.
So they just have to give the clause if the single family is over 15 years.
No, they should give it. No, they should give it
They just should give it
always.
regardless.
Yes. Yep.
I have another question. I can't remember, so I'll come back to that.
All right. It's confusing, isn't it? See why we can't answer questions on the phone while Lexi came up with her question again?
So let's say someone doesn't give the notice. It's over 15 years old, single family. That house now becomes included in rent control for that tenant, and then that tenant eventually moves out. Is that always going to be under rent control, or can you just give a notice to the?
You would give a notice to the new tenant.
Okay, and
Right.
it no longer will be under.
Correct.
Okay. Correct.
So for clarification, you said that officially that this piece is not supposed to be in effect until July of this year.
Right.
Okay. In the meantime, is there any indication that zip forms are already included in?
Oh, they are. Oh, yes. Windforms already has this in their contract. They've done a good job. Yeah, CAR has done a good job on that. I like their form a lot. Yeah. And our attorney does. Michelle.
If I bought a house and let my daughter live in it, but then rented out another room, am I stuck as a no fault because my family lives there, or is?
Well, what are you talking about? You want to move the tenant out now or what?
Yeah. Tenant turns out to be a troublemaker, my daughter's mad, and I want to get the tenant out. So which category?
I would give that person a notice that this is not under rent control. I'd do it right away. And then I would go ahead and give notice to vacate. That's what I would do. Look, I should have a disclaimer up here. I'm not an attorney. I don't give legal advice. You know. But I've been in this business for 34 years, 32 years. I've been licensed for 37. You know, I started when I was 10. Yeah. And so that's what I would do. And I bet my attorney would completely agree. Go ahead and give them the notice. It's not under rent control, and here's your notice to vacate. How long has the tenant been there? If it's more than 30, if it's more than a year, you got to give them a 60-day notice. Under that, you can give a 30-day notice. Question? Yes.
So what if it's
What's your name?
Estella.
Estella. Okay. What if you want to bump your roommate out?
Yeah.
Well, that goes to the scenario she was just talking about.
Yeah, that's what I was thinking.
Yeah, if they've been there more than a year, you know, or under a year, give them the notice. This is not under rent control, and then give them the proper notice. They've been there more than a year, 60-day notice. Under a year, 30-day notice.
But I don't have to give the free rent back.
No relocation, not because you're not under rent control. Right.
Because I gave them the notice and not.
Mm-hmm. Yep. Covered your bases. Yeah.
For
John.
houses that are single family,
Jason.
titled as single family residences. Once you give the notice, do you have to give the notice a second time?
No, it's a one-time notice. It's a one-time notice. Yeah.
How's it working with accessory dwelling units?
Well, okay. Now, accessory dwelling units. So you built a second property unit on your property. You live in a single-family home. They live in a single-family home. That's how ADUs are viewed. I only know this because I have a guest house on my property that I rent out. So I address this real quick. And the answer was from our attorney that no, you're not under rent control. Now I'm giving them a notice that says you're not under rent control, and then I can treat them as though they're not under rent control. Give them a 30-day notice of the, you know, if they're not in a lease, they've been there less than a year, and then a 60-day if they've been more than a year. Add on, Steve. Huh?
The city of Sacramento is different though.
Yeah, it is.
There's no exemption if the owner lives in one unit and the other unit rented out. In the city, that's still under rent control.
Yeah, I try to limit this to statewide rent control because you have all these other jurisdictions, and whichever one is most restrictive, that's the one that applies. So you got to know all of them, and then you got to be able to compare the particular point of clause in each one that you're looking at and figure out which was most restrictive. Yeah.
Is this pertaining to Placer County, or are we just talking about Sacramento?
We're talking California.
All of them?
California. This is statewide rent control. Assembly Bill 1482, California rent control. Yeah. Good questions, guys. Look, you're firing them at me, and I'm going to tell you something. I asked my attorney a question we presented last night, and the question came up, and he went, I don't know. There's a number of things in this bill that are going to have to be figured out by the courts. The lawsuits are going to come before them, just like the Uber case with AB5 and the independent contractors. Uber's just saying, heck with it, sue us. Let's go fight it out. And there will be big corporations who do that with this as well. Okay, exempt family, we talked about this. This slide should have gone before the other one. So provided tenants have been properly notified, those are exempt, and certificate of occupancy has been within the last 15 years. By the way, that is true. Not built, but certificate of occupancy was an issue in the last 15 years. Hey, Joel.
Question.
Yeah.
So for single-family homes, you have to provide the notice before July 1st. But if it's within the past 15 years, if it was built 5 years ago, do you not have to
So
provide that?
Joel came in late,
That's
right?
okay.
And we're going to reprimand you because
It's okay.
I just talked about, I was teasing you.
just
I'm
did.
teasing you. Joel's a friend of mine. Joel's a friend of mine. And so what we talked about is the fact that we give the notice now. We don't wait till July. Because attorneys are arguing that since the lease expires at the end of July, or the tenant will still be there after July, it applies. So I don't want that noise if I have to go to court. I don't want all that static. Let's just give them the notice right now and get it over with.
So even if it's newer than 15 years,
Yeah,
you still have to
absolutely.
provide the notice?
Absolutely.
Okay.
I'd provide it on a property built yesterday.
Okay.
Absolutely. Mhm. Yeah, absolutely. What this means for realtors. You got to know how the buyer intends to hold title. You might be selling your investor. Think about this. I don't know. They come to Roseville. They go, oh, what a great place to buy a single-family home, and they buy a home that the owner's living in, and they say, hey, is this under rent control? You go, no, it's a single-family home. There's no tenant here. They're not under rent control. But you didn't ask how you're going to hold title. Because if you say no, imagine you said it in a text or an email. No, it's not under rent control. And then, and people do this. They hold properties in corporations. Most of the accountants and attorneys I talk to say don't do that, but some people do it. And so then they turn around and hold it in the corp, and it's under rent control. Do you think they might come back and have a talk with you and your broker and maybe the DRE and maybe an attorney? They want some damages. So be careful, don't give out misinformation. You got to know when the certificate occupancy date is and know which rent control ordinance applies. Think you need some help on that? Yeah. The Rental Owners Association is really taking off right now. Because of these kind of things. People need some help on this. Also, know the date of the last rent increase. You can only raise the rent once a year.
Regardless of ownership,
Huh?
regardless of the transfer of ownership.
Say it again.
If you have a tenant, if there's a tenant already in there,
Yep.
regardless of the change of ownership.
Oh, I'm sorry, yes, regardless of change of ownership. This is all about the tenant's world. We live in the tenant's world now. We can do all these things outside of our world, but they're in a little glass bubble and protected. In fact, the Sacramento version is called the Tenant Protection Act.
So on the Sacramento one, I just printed everything out, and one of the things that it talks about is that if you want to raise the rent more than the 50%, like depending on your roof, so
Okay.
you have to go in front of, they didn't say who and what department they authorized.
All that's still being figured out. Now in LA, they have rent control boards, in a lot of the Bay Area, rent control boards. Here they're talking about establishing a rental hearing officers. Oh yeah, and rent control boards, they can charge landlords fees, they can pay themselves whatever they want, they're a board. And most of the boards are made up of 5 members, only 2 of which could own property. The other 3 must be tenants. This is real fair. They're stacking these odds. I mean, rental control boards, and here's the problem. I'm going to give you a scenario about a real case scenario that just happened recently to one of my clients. And he did substantial remodel. He could go argue his case, but nobody's set up yet. There's no one to go talk to yet. So he has no appeal. Nope. If landlord has a gripe, there's nowhere to go right now. If tenant has a gripe, there's tons of free legal for Northern California legal services, and so on and so on. And then the last one down there, rent rollbacks. Okay, there was a clause in this bill that survived, and it requires landlords to roll the rent back to whatever it was on March 15th, 2019. Plus, they get to add their CPI. Huh?
Not the 5%.
5% plus CPI, so 8.3%. So put your pens down for a minute. I'm going to read you a story. I wrote this last night about midnight. Then I was up at 6 o'clock this morning presenting all of this stuff, and now I'm doing it again. I'm beat, but I'm going to do this because this is important. The effects of 1482 had a great effect on one of my clients who lives in the Bay Area. His name is Matt. He's in his mid-40s. Good guy, works really hard. Got involved in real estate back in 05 and 07 and all that. Bought a bunch of stuff, didn't really know what he was doing. Had a crash, he went bankrupt, lost everything. Licked his wounds, got up. He's got a good job. And he decided, he had his IRA, his retirement going. And he decided, I want to someday retire to Auburn. I love it up there. I want to own a rental property. So he took his money out of his IRA, got into a self-directed IRA, which I highly recommend, by the way. I do that. And he bought a fourplex in Auburn. I'm an older fourplex built in the 60s, I'm guessing. Average condition, you know, tenant occupied. And he's like, I'm going to do it right this time. And he did. He really studied and had all his numbers and ran them past me and Steve. And I was like, okay, this guy's really thinking. So he bought this older fourplex and asked me to do a rental analysis. And I did. Actually, Steve did, or Ben, or somebody. And that's Ben. He's my son. He also works here at RentPros. And those guys actually do a lot of the work here, things I'm talking about. And they said, nope, this guy's $300 a month under rent on all of these 4 units. Each one can go up $300. So he's leaving on the table $1,200 a month. So I went back to the owner and I said, you know what, your $300, let's not kill the tenants off. I mean, Matt's a good guy. He got to know his tenants. He knew their names. He, had dinner with them. He'd been in their properties. And he goes, no, I can't go 300. I recommended 200. Let's be nice. Let's go 200. And he goes, nope, I'm not going to do it until I finish the remodel. And then he told me about all these plans. He was going to landscape the outside, paint it, put a new roof on, change some drainage, go inside. And he did. Matt went into this unit because it's his pride and joy. It's his love. It's what he wants to do. It's what he wants to do with his retirement. It's how he wants to own this thing free and clear in 20 years. And it's making him, whatever it makes, maybe there'll be $2,000 a month, $8,000, and it's going to be part of his retirement. And he says, I'm going to do all this work. And he did. And he went in and he put all new kitchen cabinets, all new flooring, all new paint, all new bathrooms, new showers, new appliances, washer, dryer, fridge, dishwasher, garbage disposal. Everything was shiny new. And he did all this work. And he called me in June. And he said, Chris, I want you to come up and see this property. I'd been hearing about it and all this trials and tribulations. And I remember this, saggy, worn out property. But it was fine. It was like every other property, every other fourplex up there. And it wasn't in Auburn Greens. It was across the freeway, actually. And I went up and I was like, oh my God, he even changed the molding on the doors to be more modern. I mean, these places were like the little Taj Mahals, and here's these tenants in there paying $300 less than, and then they had to move out some of the work, and he put them in hotels. And I mean, the guy is just, he really went all out for these tenants, these people that he wanted, like a little hen with their eggs, and just taking care of all this. And he says, I'm ready to raise the rents. And so we raised the rents $200 in June. And we went through and we had the tenants sign new leases, which they were thrilled to do because they were worried. Look, I know we're behind and we're making them way nicer than the neighbors. This guy's going to want $500 more a month. I'm going to have to move. And he went $200 a month. So now he has $800 or more a month coming in. And Matt's a clever guy. Matt's not a dumb guy. When he did the remodel, he got enough loan such that his payment was $800. So he knew his increased rent would cover it. Actually, he had to kick in a little more funds out of his IRA. The reason I'm telling you so much about Matt and his personality is because Matt's not unique. This is the mindset of most of my owners. I manage mostly for what I call mom and pops. I'm a mom and pop owner. And we're not out to kill our tenants off any more than the grocery store or anybody's out to charge so much, $10 for a loaf of bread that you can't sell. We're here to keep it all going. We're trying to run a business. And this is how most of our owners operate. Yet you listen to the media, here I go on my political, and they talk about landlords like there's some kind of villains, like there's some kind of, we went to a presentation put on by a government agency about renters, and then they were saying air lords, what was the other things he was saying? Air lords, and he was telling about, control, and he said, and then there's landlords, and he was just, making them out like these, beasts. And that's not the case. You know who is more like that is my corporate owners. Okay, lease is coming up in 2 months. I get a call. Hey, how much can we raise the rent? Hey, why do we have so much expense? Hey, let's cut back on it. No, don't put a new air conditioner. Put a used one in. On and on. This is my corporate owners. AB 1482 is, you're going to see in a minute, taking guys like Matt, and they're taking them out of their mom and pop mindset, and they're giving them a corporate mindset. And so Matt said, okay, I got my $800. My second is covered. This is real. All I got to do is hold on to this property for 20 years, and I'm going to pay it off, and I'm going to be. Well, what happened January 1st? Who knows where I'm going? What happened to him January 1st? His rents went right back to where they were in March. And he called me so damn mad. And I've never heard Matt swear before. And he was so upset, and so he had to roll his rents back to what they were in March, but we got to add the 8.3%, so he took an immediate $540 loss. And in January, this month, he had to write a check for $540 so people can live in a property that he built, and we did. And he is guaranteed loss of $540, over $6,000 a year, guaranteed loss in actual funds out of his IRA account before maintenance, repairs, or anything else, or he's now negative cash flow. And that's one of the effects, a real live effect of this rent rollback. And that's just not right. I don't care how you slice it. And here's the thing. Yes, if there was a rent control board or a hearing officer, he could immediately file and go in and get, the tenants were happy. They signed it. I mean, can Matt go in and say, well, let me finish that thought. There's no rent control board yet. There's nobody set up. There's no one to complain to. And who knows when there ever will be. So right now he's just having to suck it up. Sylvia.
Okay, so you're saying that if you, like, if you knew the rent control starting in January, let's say we're back in September of last year, and you say, well, I better raise the rent now so that I'm covered for next year, and you raise the rent in December.
Yeah.
Are you saying now that January 1st it has to go back to what it used to be in March?
Yes, plus 8.3%, yes. So if you have raised rent since March of 2019, you immediately need to do a rollback. Otherwise, you are going to be in violation of the law and subject to civil penalties and such. It's the same as going out and stealing money from your tenant. You're a criminal. Mitzi.
So since there is no board to go to and say they were happy with those leases,
Yeah.
how, like, if nobody was aware, how were they aware that it had to be rolled back and who actually did that?
So, landlords are being charged with the duty of care. And they have to take care of it. They have to know this. And furthermore, to add to what your concept is, the tenants, if we went to them and said, well, we know it's this and that, but, would you mind, getting into this agreement? And that would be an illegal act on Matt's part, for which any one of them, if they had a beef with him down the road, could bring that up and sue the bejeebers out of him and tell the other tenants to do the same thing. He could lose his entire investment. So he's stuck. And we'll talk about what he might do to get out of that situation in just a second. Somebody else had a question. Yeah, Lexi.
You could have given them a 60-day notice if it was prior to December 31st, though.
You know what? We canceled all notices unless it was for some real tenant fault issue. We just canceled them all back in November. And see, back to your point, Silvio, we didn't know this was going to happen in June, March, April, even until the bill really was passed, which was August. We didn't know what was in it. We had no idea. So we couldn't prepare. And the minute they signed it, this happened with the city when they passed theirs, the minute they signed it, all these landlords started doing this, giving notices and stuff, and the city of Sacramento did stop. They did roll back. No, you can't do that. They can't give notices. And so.
Another question, what if you have a mother and her young daughter living in the house, and the rent is $500 and the woman's sister or husband moves in as a tenant,
Okay.
and you charge an extra amount for that? It's not really raising rent, you're just charging rent for a new person, additional.
Well, whether you can raise rent or not would be something, it's guesswork, I don't know, but what you could do is say, hey, you just violated your lease agreement, here's a 3-day notice to get that person out, to move that person out. Now, if they don't move that person out, then you could go to an unlawful detainer and evict them. But try to prove that. What are you going to do? Put a private investigator in front of the house 24 hours a day? Yes, you will need to do that, to prove your case. And so it becomes difficult in that situation. But as far as raising rent to accommodate that, I would think absolutely not would be my first notion, because what if he did apply with the mother in the first place? We wouldn't have raised the rent because there's 3 people. And then so the fact is, now that they've violated the lease agreement, you would act on that as a violation. Yeah. I see a lot of head shaking in here. There's a couple opportunities that come out of this. Jason.
Multifamily housing, is exempt if you live in one, do you live across the
A duplex is. A duplex is exempt if the owner lives there. You accept City of Sacramento. But what about, I don't think you can have a 100-unit apartment and move in. No, that's. I think you may be confusing when you want a tenant to leave, you can ask them to leave if your immediate family is moving in.
Okay, but it doesn't have to be immediate, then it could be like somebody
Put that in front of a judge and let me know how it goes. I wouldn't want to be on the defendant's side of that argument, but yeah. Meet my cousin Louie. He's from. All right.
Oh my gosh, I just have to say, you guys, I'm having nightmares because I have a lot of investor clients that don't own property management, and I just like seeing all these nightmares.
Ask them if they also drive a car with no insurance.
They have insurance, I don't know what it is that they don't have it, and
Okay, so here's the thing. Here's the facts. Before rent control, you look at other countries and areas.
yeah, they're from other countries.
There's other countries that have very strict rent control. There's places like LA and stuff that didn't have it, and then they do in the Bay Area. Everywhere there's no rent control, about 30% of owners have used property management, and 70% are DIY. Under rent control, that flips, and it goes to 30-70. So look for those landlords. Our phone's already ringing. You know, our property management company's already growing because people are like, okay, I'm not doing this anymore. Yeah, they can't do it anymore. I mean, folks, we can't do it anymore. We have to have, I mean, I talk about Thomas Hogan. He's practically an on-staff attorney, you know. It's constant. It's constant. We're asking him, and he'll tell me one answer, and Gary Link, the attorney, will give me another one.
I'm going to his class, too, he's gonna have an 8-hour class.
Gary?
Yeah.
Yeah.
Give him the location and the date.
Well, he might do it. I mean, I was talking to him about, we were talking about him doing classes here even, so, yeah. Yeah. Back to our scenario. You want to sell a duplex. The owner wants to tenant out. What are you going to do? Huh? There is a way. You could bargain with them. You could bargain with them. That's one good way. You can say, hey, let's negotiate. I'd like you to move, and you can negotiate with the tenant. And then they get to call the shots. And if you might be one of those people that say, I only had to pay him $18,000, right on, you know. The other method is this, and this will probably be more common, or as common. You're going to say to your buyer, well, look, I can't move him out because my immediate family member is not moving in. Yours is. So we got to close escrow, and then you got to give the tenant the notice and go through the process to get them out, and hopefully not through an eviction, and then you move your immediate family member in. But remember, Mr. Buyer, now you got to pay relocation fees. Now, if you're an agent and you don't make your client aware of that, or you forget one part of it, and all of a sudden they go, what? Relocation what? Nobody told me about that. They may come to you and say, help me out here. So we don't know.
To 1 month's rent. Minimum.
1 month's rent. Mm-hmm. Yeah. Yeah.
Any word around the legislator about trying to increase that?
I don't know. Probably. Huh? Mm-hmm. That's if they still move out. They may not move out. Then you have to go to straight up eviction, yeah.
So I was at SAR in November, and there was a panel, and this is for topics of this coming up, and it was brought up that there's a legislator, some kind of bill that they're waiting for her to sign, so it doesn't go on the ballot, but if she doesn't sign, I can't remember her name, then it's gonna go on the ballot, and then we can vote against it and turn it around. Have you heard about that?
No. What I've heard is Proposition 10 failed, and they've got Proposition 10 2.0 coming up to try and do it again. And they're going to take away a lot of these things. So let's see if I get, where did I put Matt's scenario? Here we go, right here, Matt's options. This kind of ties in what we're talking about. What are Matt's options? Well, one, he can hope that the tenant stop paying rent and they default or something and won't let him in or something so he can evict them for a tenant fault. You see how Matt now is starting to become a corporate thinker? In fact, I got off the phone with Matt before I did, after he threw his rant, and he said, Chris, from now on, I want the rents raised as soon as possible, as much as possible. And don't miss the dates. That's Matt now. That was not Matt when he bought the house, the property. It's Matt now, and it's everybody else. They're turning us into corporate-minded owners, and that's not good for tenants. Like I said, I think I said it earlier, the average rent increase is about 3 or 4% historically. Now we're going 8.3 every single time. he can sell the property and say, I'm done, but now the new owner takes over his low rents. So what just happened to the value of Matt's property? It got stuck. It's low because in investment property, the value of the property is based on the net operating income, which is based on the rent. So he just lost $6,000 a year minimum. Well, heck no, he lost more than that because he was $800. He went to $5,000. Yeah, $6,000. What's the cap rate on $6,000? $30,000. So at a minimum, his property just went down 30 grand. Sure, but so will everybody else. I mean, he could do that anyway. So now he's just forever behind until maybe a tenant will voluntarily leave. Not bloody likely, as they say, because they're way under market, right? They're way under market. Oh, they might move after a few years and some rent increases and something happens in their life, but it's just an awesome property. I mean, no one in that socioeconomic level is going to move out of that property unless they have a darn good reason. He could schedule a substantial and necessary remodel, except that he just did that. One that required his tenants to vacate, but he just did all that. And so he doesn't have any room to wiggle there. He could move in. He said, I'm moving into the property then. He's going to move into Unit 1 and live there for a year, and then move into Unit 2, and then move into Unit 3, and then move into, yeah. So, I mean, he's trying to do all kinds of scenarios, and he's got to be there for a year, so that's going to take him 4 years, you know, and he lives in the Bay Area, and so I'm like, Matt, don't do it unless you're really going to, you know, I mean, you get into court, they're going to start asking for anything from, you know, gas receipts to, you know, tax bills and everything else, yeah.
So, let's use these numbers. Let's say rent on each of those units was $2,000.
Okay. Okay. Okay.
So we can roll them back to the $2,000.
Okay. Fair enough. Yeah.
Okay. So we can rent them, adjust them up 8.3. But if somebody moves out, can a new tenant come in at 23?
So that's a good question. Tenant moves out on their own accord. Now I've got a vacant unit. Can I raise the rent to market rates? And the answer is yes. Because what was in the bill was something called vacancy control, meaning that you couldn't do that, but we got vacancy decontrol, so that got taken out, so that now, yes, you can do that. But the proponents of the bill are after that. They want to control it even when it's vacant. They want to control it even when it's vacant. Or he can just suck it up and increase the rents 8.3%. That's his options. Well, that's kind of it for my presentation, except that, you know, if you want to stay current, you really need to educate yourself. Even as a realtor, join the Rental Owners Association, the California Apartment Association, go to the classes, develop a good relationship with an attorney, right? Now, at RentPros Property Management, you know, we do have a bulletin where we're going to be shooting out things. We offer the classes, you know, here, and the Rental Owners Association. Now, the Rental Owners Association is it's $179 a year. You will get an email in the next by tomorrow that will give you a $50 off if you want to join, and yeah, that'll be good for like till Monday or something. So, yeah. So if you want to do it, get that email. Just join up. And now you can come to classes. Not all the classes are free. A lot of the services are not free, but they're discounted if you're a member. And, you know, we're here to try to educate now and get this, do what we can. Maybe someday we'll form a PAC. We're actually reforming right now. We were a profit organization. We're going to be a nonprofit. And so maybe we'll form a PAC and support some candidates, that kind of thing, because that's where all this comes about. Without getting too political, somebody at a seminar asked me, well, who's doing this? Who's making all these rules? What's going on? What's going on? I said, well, the legislatures are. And somebody yelled across, who? Give me some names. And I said, it's easy. Go look at go look at who's supporting and who's opposing all of this. It's not like it's bipartisan at all. This bill is 100% partisan. One party voted yes, and the other party voted no, and that's true for the Section 8. And there was over 100 bills passed having to do with the rental industry this year alone, and that's pretty average, about 100 a year. And these restrictive are one group, so you really need to educate yourself and notice who you're voting for, not just be a one-issue person. I mean, this is really an affront to me. This is an affront on property rights. It's an affront on capitalism. You know, it's an affront on. It feels to me. I feel like, you know, when I was a kid, we'd play Monopoly, and, you know, if I won, yay! And I feel like, you know, I'm 62 years old, and I bought rental properties 30 years ago, and we hold them, and we do our exchanges, and we do all our stuff, and we build, and we're playing this Monopoly game, and at the very end, someone goes, and they change the rules, and we're all going, whoa, we would have played it different if we, but, so, you know, I'm not crying or anything, but, you know, a lot of people, like Matt, got really stuck. And this is not unique. We have multiple owners. How many rollbacks did we have to issue, Steve? Yeah, a little over 40 rollbacks.
I gave my tenant a $35 increase.
You gave him 35 since March?
March, June of last year, I gave him $35.
So that's probably less than the 8.3%.
Could have gotten 120.
Yeah. So see, you're a landlord. You're a mom and pop, aren't you? You got that mindset. You got that. You're not, but you're going to start to get, and you're going to get a little. You're going to harden up a little bit. You kind of have to if you're going to be in this biz. Now there's still opportunities. Remember I talked about Matt's value of his property went down. I talk to landlords all the time, and they're going, "Forget it. I'm selling. I'm out of here." Well, the value of their property just went down. It's not a good time to sell, but they're doing it anyway. So if you're a buyer, I'm looking at a 12 flex right now that they're thinking, I need out of here. I want to get out of the state. They want to do this and that. And I'm grinding them on price like they can't even believe it. But I'm like, you've been on the market 60 days. Your value just went down as of January 1st. Take it or leave it because you're going to keep owning it. And so as a buyer and as a realtor, you can work with your clients and say, now's the rent control opportunity. And if the rents are less, they're going to buy it less. And now they get to start their thing up, knowing that rents always skyrocket under rent control. So we're looking forward to that, frankly. Yeah, you got to deal with all these minefields, but that's why you have us. That's why you have attorneys. That's why you read. That's why you watch what you're doing.
So if, let's say a property is bought for investment and there's actually owners that live in it, then you can set the, rent, and that your intent is to rent it, is that market value at that point.
So you buy what kind of property are you saying?
A single family,
Buy a single family.
but it was by people who lived in it, it's owners
Yeah.
that lived in it.
Uh-huh.
Now, when you go to buy it as an investment and you're gonna rent it out.
Okay.
We just rent it, you find out what the market is.
Yes. Yeah.
Throughout
You can set your market rent.
Set it whatever you want to.
Yeah.
As long as it rents.
Yeah. Set it at market rent and then give them the notice so that they're not under rent control and you're off and running. Mitzi.
I just wanted to share that, I know at Foster County Association of Realtors, there is a team that fights with works with, they're fighting against the action fund that we contribute to. That's what the funds are. They're with legislation all the time, working on trying to fight against it.
This is the first year I've ever paid my dues and given to that PAC fund. Yeah. Yeah, I gave to him. And you know, I was very happy, I should say proud to be a SAR member, Sacramento Association of Realtors member, because they fought this tooth and nail. And I'm also a member of the California Apartment Association, and they capitulated. In fact, they capitulated. Citrus Heights came up with some measures of their own, and I don't want. CAA was not working as hard as I went down there and met with the city and the mayor and the police chief and a whole host of others and said, no way, on our behalf of our group, we got a little bit of clout too. We're not going to accept this. And fortunately, they gave us that little piece we were asking for. But it takes that. It takes that fighting, you know. It's
I think it's in May, they have legislative day. I don't know if you've heard
Yes.
of it, but I went
Yeah.
what's in and to talk to them and so it's
Yeah.
call to do.
Have you done Ledge Day?
Yeah.
Yeah, I've done it too. I do it with the property managers. You do it with the realtors. Yeah. Yeah. Question.
The other thing that's important is the AR and FAR that we get on our alerts when you sign up for it.
Yeah.
You get on alerts, 'cause when I get my red alert, then they'll give us instructions, and we'll get the bill, and get all the information, and pick up the phone and start saying, and they'll give you a script, so you
Yeah.
can say exactly what you need to do. Like the, yeah. Call the
I don't know how much good that does, but it sure can't hurt.
Oh, I take action all the time.
Yeah.
Yeah, this one's the worst thing. I even asked our mayor, City of Sacramento, in the city.
Yeah.
I said, so mayor, how many rental properties do you own? And he goes, none, and I said, I don't need to go buy one.
You know, you're talking about.
I told him that, he doesn't like me, I don't like him.
Yeah. Well, he used to own rental properties, but he doesn't any longer. Yeah. He sold them.
But he acts like he.
Yeah, well, I used to be the government affairs director for the Rental Housing Association, so I would meet with all those guys. And, oh, yeah, they promised we would never vote for rent control, you know, Ashby, I would never do that. And when we gave her $1,000 or whatever it was, and then, lo and behold, she voted for rent control, Angelique. Yeah. So, and the same for a number of those guys, so that's the deal.
I think they're kind of, their mindset, I think people at Beaufort think it's gonna help keep the rent down. They don't understand the free rent voting.
When you call a bill the Tenant Protection Act, and, 40, 50% of your constituents are tenants, oh yeah, the tenant, they don't realize if a jerk neighbor moves in, I gotta live with them. They don't realize that. Why don't they look at the papers? Why don't you look at and Google it and see what happens under rent control? The rents keep going up.
If you guys go back and watch the videos, I was there and I said to them, what you guys are doing is like investors will buy a house and they look at the house, they rehab it, you go and see it, it looks great. Then you look at another one and you can advertise this house on the block and you did a great job. And I said, we call that lipstick on a pig. And I told them in front of it, it's recorded. This is what you guys are
You were
doing.
down at the hearing down at the city?
Yeah, I go there all the time.
I was there, yeah.
I'm the community leader for Councilmember Larry Carr, so.
Okay, great. Yeah.
But I told them lipstick on a pig, and I was even gonna like pay for it myself and get them all a shirt that had a pig on there, a big lipstick.
You know what you ought to do? You ought to let us know what's going on, and I'll notify my group, and we'll when we go down there. We light our torches and pitchforks, and yeah.
And the realtor car, everybody, is that down at City of Sacramento?
Yeah, Tuesdays.
Yeah, we can all go as a big group, that would really
yeah.
be.
Yeah.
Yeah,
You
we wear
know.
our Meadowview shirts and we're there.
Yeah.
We're relying on you to support.
Shoot me an email. Let me know. Shoot me an email. Let me know. Let me know. We'll get it out to our group. Okay, folks. Well, thanks a lot. Thanks for coming in. You'll get an email. Think about that Rental Owners Association, and we'll be a team here.
Showing up on that rental or your RentPros, because I know that the contract that's out there